Hey guys, last minute stream here. Let's see if it works. And that's because there is a document filed in the Richard Allen case. If you watched the prior stream, you know that I said attorneys like the last word, of course. And Allen's attorneys are seeking permission to do that, or they sought permission to have that, and they got it from the Indiana Supreme Court. It said, yes, you can file a document responding to what the judge and the attorney general said. So let's take a look at it and see. Thank you for commenting on this tree. Mrs. Southern-in-law put it here, and she's worried I'm going to knock it off this desk, and I will endeavor not do that during the course of the stream. So let's see what we got. All right, so this is for the original action at the Supreme Court seeking reinstatement of Rozzi and Baldwin, removal of Judge Gull, and the setting of a speedy trial date. I don't think they're getting the third one, but let's see what you guys think. I'll skip the table of contents because we'll actually look through this. I haven't even really glanced through this yet. Here's their summary. So here's a roadmap of what they're going to tell you with the old maxim: tell them what you're going to tell them, and then tell them what you told them. This writ is the only remedy. Any trial without Baldwin and Rozzi, Rick's counsel of choice, would be merely for show. Only two lawyers can be ready for a speedy trial and carry out Rick's well-developed trial strategy, and only one court can grant that relief, this court. If action is not taken now, his trial will be delayed longer, and even more public resources will be spent. More importantly, the public's trust in the judiciary will be permanently undermined while the world watches, and appeal is inadequate. Maybe that's partly overwrought, but at its core, it's true that if he had his original attorneys, his case would be on track for trial, so far as we know. And now it's in a substantial posture of a substantial delay, which usually means more expense. Of course, it's prejudicial to him. And, you know, everybody wants the speedy trial. That's generally better for everybody as long as you can get it done. And he had the attorneys to do it, but the judge felt like they should be taken off the case, and that's what she did. And if I move this, it won't show up anymore. Then, okay. So, but thanks. I'm acting like my left arm won't go anywhere. This case presents the paradigm situation for a writ of mandamus, and they say this court routinely relies on its original jurisdiction to address claims where attorneys have been or should have been disqualified. And they list several of these. One of those you'll see there is the Jones versus Knox Superior Court, and that's going to be something I think I'm going to refer to because it's already been cited in their original brief and also in the judge's response. So that's the one where the attorneys made a sarcastic motion to the court, at least that's how the court saw it, and said, well, if we don't get what we want to move to withdraw. And the judge said, well, how about this? I just kick you out of case or refer you over for disciplinary action. And then the Supreme Court said, we're not going to issue a mandamus to reverse that judge's decision because all that judge did was put you in a position you asked to be in. So that was a good case there. It is ceramic. Okay, I see that. It's news to me. I haven't touched this thing. Okay, it's too precious for that. If they get lawyers, a new judge, then speedier trial. And potentially, you know, of course, it depends on when a new judge would be ready to try the case. The court's not going to be in position, I think, to set down a speedy trial date of 70 days if you don't, you know, if you don't know what the new judge's schedule is going to be. So I think that's out the window. But anyway, let's move through this. The respondent, which is the judge here, and the attorney general do not dispute, Allen's team says, the fact that original jurisdiction has been used to address disqualification claims. The unlawful disqualification of an attorney strikes at the heart of the public trust in the integrity of the judicial process and requires this court to invoke its inherent authority to supervise the conduct of the lower courts. Okay? So far, so good in terms of following where they're going with this. The judge severed the attorney-client relationship on her own motion and over Rick's objection. Okay, so all right, we're already here in this Knox case. The judge, they say, misapplies the Knox case when she argues a writ is inappropriate. In Jones, this court denied a writ of mandamus and prohibition petition that challenged the trial court's decision to disqualify criminal defense counsel in a murder case. There, the attorneys initiated their own withdrawal, but the judge didn't, I don't think, sustain that withdrawal. I think the judge just said, no, I'm kicking you out of here. Okay, that's what I'm doing. You're not leaving. I'm kicking you out of here. The court did not deny the writ for failing to have a clear, unequivocal right to reinstatement of counsel, but because the court will not countermand the trial court's ruling, it placed defense counsel in precisely the position their motion indicated their willingness to be. Right. So they had said in their sarcastic motion, we want to withdraw if you're not going to give us the continuance. And the judge said, well, why don't I kick you out? And then the court said, well, since you wanted to be out anyway, we're certainly not reversing the trial court's position. So what I did think was significant in that case for Allen's side is that, as they say, the court did in fact entertain the writ, but simply said we're not going to allow it in this case because you got the remedy you asked for. This court did not doubt for a moment that a court-initiated discharge would properly fall within the court's original jurisdiction. How do you know they didn't doubt for a moment? It did say that they got together and met about it and all that, so it could have had a momentary doubt. But this is advocacy writing, okay? So maybe and maybe not, either way. And they did say this, though, which they said that this court, and this was in a case, this court is generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. But then they said we're not going to explore those limits, and here's their chance to do that, in my opinion. Here, the judge made it clear that she was discharging attorneys Baldwin and Rozzi on her own motion, regardless of how defense counsel proceeded or what the prosecutor wanted to do, and that she suggested they read between the lines. We all know that. You're a lawyer. Reading between the lines is what you do for a living. Okay. Eventually, she made it clear that she was unequivocally severing the attorney-client relationship. There's no situation where the attorneys could proceed with representing Rick. And I think that is clear from the transcript. That's what happened there. I don't want to do this, she said, but I will if I have to. And the what was disqualify you in open court, throw you off of this case. This originally came up in theory because of an informal phone call in the state saying maybe there's a disqualification situation here, but it moved from that to the judge deciding that is what would happen. Now, I know there's a lot of due process talk and things like that, but also consider the fact that in that Knox case, the judge just decided, sua sponte, I'm kicking you off of this case, and there wasn't a lot of talk about all these other things. So I think, it is true here where the disqualification was going to occur based on a finding of gross negligence and incompetence rather than disrespect to the court, that the right way to handle it would be to get those things onto the record, all the things that were going to be the basis for it. They kind of are now because we have this transcript, right? Now, it is true, though, I think that the attorneys for Allen, Rozzi, and Baldwin, they didn't know what was going to happen if they walked out into the courtroom. They didn't know what the state had prepared in terms of what they wanted to present, and they were left really in a bad pickle there. So that is different than the Knox case, where the judge's decision was basically based on that motion that was filed, and there wasn't going to be a hearing about witnesses and things like that and a long history of behavior. But I think it is important to remember for the anti-Allen side that in that case, the judge's decision to throw those attorneys out based on a stupid motion, at least as the judge saw it, that was sustained by the Supreme Court. So that ought to key you back in that there are in fact limits to the attorney's ability to stay in the case. It's not an unqualified thing where you can do whatever you want, whenever you want. I certainly would have never believed that I could do that, treat a judge however I want, and then tell him you can't do anything to me because of the Sixth Amendment. I don't think anybody really thinks that, who knows what they're talking about. All right. And so there's a big footnote there. And then the court said, I'm doing this on my own motion, so there wasn't going to be anything from the state. They didn't have to file anything. She was going to boot them off the case. Attorney Rozzi Baldwin offered an alternative to avoid eliminating the entire defense team and ensure a semblance of continuity of counsel and efficient administration of justice. That was when Rozzi said, hey, is there any scenario if you determine to boot somebody off the case that is just Baldwin and leave me on it? Wasn't my conference room. I wasn't controlling it that day. I know the case. I'm ready to proceed. Can we at least do something like that to salvage this? And the court's answer was 2 letters, which is formed the word no. Then they spoke with Allen, which here is presented in the first name, short nickname basis, Rick. I still would prefer to see that as Mr. Allen or something like that rather than, that familiar to it, but everybody do it how they want. But we are talking about a brief at the Supreme Court. The attorney suggested that the judge hear directly from Allen, which we know that happened. And that didn't happen, of course. They didn't, they were worried about him self-incriminating or something like that, Fifth Amendment issue. I didn't quite catch that, I think, if he was speaking on the record without counsel. So they suggested bringing him into chambers. But, you know, just asking a guy, do you want these lawyers or whatever? It's not really, I mean, does he want to say that or not? But it was certainly on short notice. So anyway, we kind of know what happened. This is really just outlining what happened. And they say the judge had an absolute duty to refrain from severing the attorney-client relationship. Not a single case has tolerated similar behavior from a trial judge. An absolute duty to refrain from it. But it's not really absolute because they start right off saying, well, now here's two situations where you can do it. So that's not my definition of absolute. Narrowly constrained, perhaps, you know, in the exercise of discretion. But obviously, they're using the words absolute duty because that's what's the requirement is for this kind of writ. But maybe the conception of absolute duty is to not violate discretion or not overstep discretion when you're talking about an important right like this. So, yeah, calling him Rick seems disrespectful, potentially, or at least a bit too familiar. Yeah, I mean, I don't think they're, you know, clearly they're not trying to be disrespectful to anybody in this regard, but it is quite familiar for a Supreme Court brief. But that's okay, as I say, it's advocacy. They do it however they want. It's not, you know, how I would normally see it. Normally this person's name or whatever is used like everybody else is. You don't have to call him the defendant or whatever, or the alleged murderer, but you could call him Mr. Allen. And it says, Rick has made it be known that he likes to be called Rick. I don't care what he likes. There's protocol. He'd like to have lots of things. We're talking about the law here. So in terms of how he might like that he could have a longer brief and stuff, but what he likes is not really controlling on how you should address the court and things like that. So it's merely stylistic. So it's fine if he wants to be called that. That's cool. It's super cool. On the other hand, the attorneys, their names are being used as last names, which is appropriate. And I doubt the Supreme Court cares much one way or the other. I'm just saying how it's normally done, whether anybody likes it or not. But whatever, it's not going to result in this thing being tossed out or whatever. I think what you can do is head off into the sunset. And see you later. All right. There are only two narrow situations in Indiana where a trial court has jurisdiction to sever the attorney-client relationship against client's wishes. Lawyer is not a member of the state bar. And here's why I removed this person, because, and that's not going to tolerate anybody who's so one-sided that they can't accept a different opinion on anything with constantly critiquing and analyzing you, especially when they don't really have the experience in it. I said it was a stylistic difference. I said it didn't make any difference. So I'm not doing trolls tonight. I'm just going to move through this. For example, Nan, who is no troll, already said that I disagree with you in this case, that I didn't think it was disrespectful and all that. It's just stylistic difference. And if that mild criticism sends somebody over the edge into perpetual argument, they won't like any disagreement on the actual law. But as I say, on the internet, you get people who, if they're on one side or the other, they can only see their side as absolute perfection, and everything the other side does is totally wrong. And that's not analysis. That's just dumb. All right, respondent had an absolute duty, but that duty is not absolute because there are narrow exceptions. And that is the lawyer's not a member of the state bar. That's clear. Or the lawyer has an actual conflict of interest that will obstruct the ability to provide effective representation. And those are two good examples. But I gave some hypotheticals because this is certainly a totally a hypothetical situation here, because it's so rare that, you know, what if the attorney were, you know, cussing the judge out in a courtroom all the time or showing up naked and things like that, and then says, Judge, you can't do anything because it's the Sixth Amendment. The judge would kick you out of the courtroom and take you off of the case, and no court's going to reverse that. Here they say no Indiana court has ever tolerated a trial judge removing a lawyer from the case over the client's objection based on anything other than these two reasons. And that may be true because the cases are quite rare, but there's 8,000 words, 50 pages. Failed to present a single Indiana case tolerating this behavior from a judge. Now this behavior, yeah, because this is quite unique, but in terms of throwing an attorney out of the case and being sustained, didn't we just look at that in the Knox case? In the Knox case, the court said sua sponte, I'm going to throw you off of this case because of the way you wrote this brief, the disrespect for the court, and I'm going to refer you to disciplinary proceedings. And the Supreme Court of Indiana said, we're going to let that stand. So that's not, that person was a member of the state bar, and it doesn't bring up a conflict of interest. So I think there's obviously room here that the court has more area to disqualify an attorney from being in a case than just those two things. But that's not to say that what Judge Gold did here follows within that or falls within that. And you didn't create any discord. You just gave an opinion, which I think is fine. But, you know, I guess maybe they do have a local rule, and I didn't see it when I read all the rules that apply to original jurisdiction that the client's preferred first name nickname is the way to address them at the Indiana Supreme Court. It might be a rule up there. Like I say, it's probably just stylistic, and it's just a choice people make. But that's not how I normally see it. Whatever. Every Indiana disqualification case cited by the responding parties involves a conflict of interest, unlicensed attorney, or a judge being reversed because she removed a lawyer from a case for another reason. But what about that Knox case? That judge, that wasn't a conflict or an unlicensed attorney, but that decision by the trial court was sustained to throw those attorneys off there because the court said, look, you got what you wanted. And that is yet a third exception. And that comes under my exception of play silly games and get silly prizes, which is if you do something super stupid in court or you continue to misbehave, it's obviously the court has the ability to control the courtroom and you don't have to deal with that. That's not the case here. Rozzy Baldwin did nothing like that. And they are licensed attorneys, and there's no real allegation, anything other than laughable, that they have a conflict of interest. So those three types of exceptions are not what's applying here for certain. And they say that the absolute duty here. And again, I think the absolute duty is more towards how the writ is required to be written than to say there are zero exceptions, but I think there are more than the two that they outlined here. Respondent obstructed the attorney-client relationship for reasons totally unconnected to the Sixth Amendment. Well, so here's the thing. In Knox, the court didn't reach whether it was okay or not to throw the attorney off the case. Well, they did, in that they left the attorney off the case. The attorneys filed the writ saying, this judge can't throw us off the case like this. And the Supreme Court said, well, we're going to deny the writ, which is they either grant the writ or they deny the writ. And there they denied it. They did not consider the writ, which, again, that's what Allen's counsel says here. It says, look, in the Knox case, the court actually considered the writ. So this is a subject that can be considered by a writ, which I agree with. But there the court denied it, basically saying, you asked to be withdrawn and you got kicked off. So either, you went different routes to get to the same location. We're not going to disturb that. And you got to read between the lines and see that the behavior that they engaged in at the trial court level, the court was not going to cause the judge to have to put up with that. So I think they did reach that conclusion because they denied the writ. If the judge was not allowed by law to throw them out for filing a sarcastic brief and stuff like that, then why wouldn't they have granted the writ? So that's my point. My point is not to say that covers Baldwin and Rozzy. It's to say that there are exceptions to this, and you can imagine some yourself probably. I mean, or else people can imagine that you can do whatever you want in court because of the Sixth Amendment. A judge is powerless to control you in any way, but I don't think that's what the law is. And that's why I'm making this point. So I don't think it applies here. So respondent obstructed the attorney-client relationship for reasons totally unconnected to the Sixth Amendment. When respondent severed the attorney-client relationship, she was acting on subjective opinions about the defense's conduct outside the courtroom. And so, see, that distinguishes from Knox, right? Because Knox was how these lawyers were dealing with the judge. A judge wasn't going to have it. And that doesn't apply here. So they're already making some distinguishment, even if they're not citing it to that case directly. The judge here, Judge Gold, they say this was not on Sixth Amendment concerns that might alter the trial's outcome. Yeah, so again, if they were absolutely incompetent or unlicensed or something like that, it's a big deal, of course. But she says that Baldwin and Rozzy committed multiple violations of the rules of professional conduct, and she acted to protect Allen's Sixth Amendment right to effective assistance of counsel. Well, that's a laudable goal, but I as I've said many times, I'm kind of on Allen's side, at least on the merits of this, that I don't personally see that. The allegation that they're incompetent at representing Allen, I don't really buy that. They may have broken a rule here or there or whatever. That's not the same thing as being incompetent to represent somebody. And I'm not convinced that they broke the rules either. The rules of professional conduct are not coextensive with the Sixth Amendment guarantees of assistance of counsel. That's certainly true. Ethical standards can apply to a broad range of attorney conduct totally unconnected to the Sixth Amendment. And again, consider the Crumley case where recently sanctions were requested against one of the defense counsel for filing things that were allegedly either false or shouldn't have been made public. And the court said, well, we'll deal with that, whether sanctions or not, after this trial is over. So you can see that court understood the difference between those two things. Attorneys Baldwin and Rozzi did not violate any ethical rules. And the judge, if she believed there was a violation of the rules of professional conduct, should have reported the violation in accordance with their obligation. Okay. That's fair. In the Knox case, the judge did that. The judge kicked the attorneys out and reported them, I believe, to the bar. This never occurred despite the judge claiming there was a violation of ethical rules nearly a year ago dealing with the press release. And I think that press release, if you want to call that a violation of the rules, is certainly a matter of opinion, because I don't agree with that. Again, coming from the standpoint that I think the circumstantial time frame against Allen is quite bad. I don't know he's innocent from anything I've seen, and I haven't sat through a trial to know he's guilty either. But I just don't see what they said in that press release is really being so over the top that, like, oh my God, I'm stunned that the defense counsel would say something like this. You hear defense counsel say things all the time trying to say that their client is innocent. So, yeah, that's a good point here. Can you imagine what would happen if the attorneys were reinstated and did another questionable thing? The judge would be blamed for having let them remain. Well, of course, the person here is calling it questionable is this judge. But if she were to stay on the case and they were to be on the case, that would be a showdown at the OK Corral. That's for sure. And in both directions, I think. And I'm sure that will get addressed in this brief, because they're saying they want back, and then they're saying they want her gone. Okay. And we haven't gotten to the gone part yet. But they're making the point that, hey, if there were these big rules violations, why didn't you refer those over to the bar a long time ago? Or maybe you were just keeping score, and then when the straw breaks the camel's back, you go back and look at all the bad things that you can think of that we did to justify how you're feeling you want to handle this current situation. These are human dynamics, after all. In any event, the judge's subjective concerns with Rozzi and Baldwin are wholly unrelated to the Sixth Amendment. Respondent's primary ground for her subjective belief about the performance was the evidence leak discovered in October. And that was the big one, right? The disqualification came after that, and the judge was upset about it. And given how things fell out in that, with what happened with the person who was involved in the leak and stuff like that, I think it is completely fair for her to be upset about it. And that's true whether there had been prior leaks of things or not. That doesn't justify prior leaks. And it doesn't make this one worse than those or anything like that. But it's, you could certainly be upset about it. But as they say, Attorney Baldwin was a victim of a crime allegedly committed by this Mitch Westerman, who took photographs of the evidence when he shouldn't have been doing that. And to me, that matters a lot, right? Like if Baldwin had said, well, look, I just decided to put these out there and let people take a look at them. I'm tired of holding this in secret, even though he's under order for discovery. That would be one type of conduct, right? It's looking at them on a subway home, which I know that's not what they have there, or bus or whatever, something like that. And people seeing them and taking pictures, that's another thing. Setting it out there and letting people in your waiting room see them, another thing. Having somebody who worked for you look at them in a conference room and take pictures of them while you're out is another thing. And while that could be said to be a rule violation or an order violation or something by Baldwin, it's certainly not intentional, right? From the facts that are out there. Was the state prepared to show that this was a big lie? I don't think so. We didn't. I just don't think so. And if they were, that should have been put on the record, because it did not make it here on the record. So getting here late, what has happened is the court allowed Allen's team to file a response to the judge and the attorney general. So we're looking at that. Now, some of these arguments will be kind of repetitive over what Allen's team originally argued, and some of it will be responsive to what the AG and the judge said. Because obviously we know that Baldwin was allegedly the victim of a crime that's already out there. And And law enforcement, prosecutor, and Superior Court have reviewed the matter and found probable cause to believe that Baldwin was a victim of a crime, and that's true too. So they say what happened to him in October and the other things did not affect the quality of their representation. I buy that. I mean, I do buy that. I agree with that. Now, whether that's not really important, is it? The thing you got to imagine is if these things happen, did the parameters of discretion the judge has within the law to throw these guys off the case, was it wide enough to allow this? Or was it so far beyond the bounds that the Supreme Court ought to switch the decision? So you can agree with Allen, but you also have to reach the conclusion that even if you agree with him, that the judge couldn't possibly have any reasonable basis to have done what she did. Not that it wasn't just the best decision or even a wrong one, but that it was really bad. And you especially have to look at that carefully because he does have a right to counsel, which he still has counsel, but the normal balancing act of delay and things like that, all those, and continuity counsel actually weighs in his favor. He was the one trying to get to trial, and it's usually the reverse when these things are upheld in terms of disqualifying people. Freezing Pennsylvania. Yeah, it was cold here. It's not quite so cold now. So they mentioned that disqualification was mentioned by the state first in the telephone conference, and we've all learned that. And the next day, Allen unequivocally affirmed in writing he still wanted attorneys Baldwin and Rozzi to represent him, and we know that's true. Trial counsel filed his letter with the court and included a lengthy letter to the court that explained that the court lacked jurisdiction to disqualify them because there was no conflict of interest. And if they filed a tort claims notice or something like that, that's a conflict to representing him in a defense case. That's, to me, demonstrating that they think potentially he has a claim. Okay, that's supportive of potentially their belief in his innocence. I don't see the conflict there, the misalignment in interest. I just don't see it. And that same day, the trial court ordered counsel to cease working on Allen's case. And sometimes I forget that fact. So that's a very good one for Baldwin and Rozzi because of the point that, well, what were we supposed to do to get ready for this hearing that you didn't kind of tell us what it was going to be, and we only had to figure it out ourselves, but we're ordered not to work on the case? Does that mean we're ordered not to prepare for this hearing? That is a very bizarre situation to be in for sure, and I think it supports their logic, in my opinion, that they were kind of, quote unquote, caught off guard, not given a chance really to defend themselves without a worst case scenario. They weren't able to prepare for it and things like that. Yes, this is the defense's final word on this because they had to get leave of court to file this because it's not allowed directly under the rules. And after this, the Supreme Court should be considering whether to grant this stuff or deny this stuff, and probably issue an order pretty quickly because a writ of mandamus, you're usually going to get the order much faster or way, way, way faster than you would any appeal that you file. This is not an appeal. This is an original action to the Supreme Court. And if they had filed an interlocutory appeal, that some of those by right can go up to the Court of Appeals and some of those are discretionary, and then you have to get the trial court to certify it for appeal and then you appeal it. And that takes a lot of time. So this is obviously, if you consider the situation critical and under what this covers, this is the way to go. And of course, it's way better than waiting to an appeal after the case is over. All right, I'm taking longer to get through this than I thought, so let me keep it moving for you. Before the hearing on the 19th, Baldwin retained counsel and filed a memorandum. And I thought that was odd at that time because usually attorneys don't go out and get another attorney just because they're facing potential argument of the court and maybe even a potential sanction. That's unusual. But what was unknown to me at that time was just how sideways this situation had gotten. And that this was going beyond like, I'm going to charge you $1,000 or I'm going to scold you or I'm going to disallow X days worth of payment for you or just warn you or whatever. This was actually, you're going to be thrown out of the case potentially, but maybe not. So it makes a little more sense, I think, that they were trying to perhaps find a way to communicate with the judge differently and get the trajectory changed. And the attorney who filed that memorandum offered in that situation, look, well, we don't think that even a sanction is warranted at this point. If you need to do it, it shouldn't be disqualification, but do this other thing. So Baldwin had offered at that point through his attorney potentially forfeiting pay as a response to what had happened, as well as changing procedures for the rest of the case. And that's normally how something like that would work out. If it warranted a sanction, it wouldn't be the nuclear bomb sanction of you got to leave out of the case. During the in-chambers proceeding before the hearing in open court, the judge revealed that on her own motion, she was disqualifying counsel, and the record definitely supports that. Rozzi didn't like it. Rozzi did some good arguing in chambers there, I think. But the judge, as she honestly told them, I already decided. So I'm not sure what the state would have been putting on out there if she'd already decided this. So that seems some overkill dunking there. But I still go with the theory that, kind of like in the Knox case, if you are throwing these guys out, and even if she didn't officially do it until later in the month, you go on the record and put on the record what all the reasons are and do it that way. I think that's an issue here. Even though you can divine from the record of the transcript what she was deciding, the basis for that, and I think that's okay. That's just, normally on an order, you would like to see the basis in the order, then the balancing that goes on inside the parameters of the law, and then the conclusion. Well, this is interesting. I think the lack of respect for decorum before the state Supreme Court, referring to the murder defendant and the familiar Rick, is troublingly consistent with demonstrated sloppiness of failing to secure sensitive evidence. Now, it is different lawyers, so I'll say that, okay, for sure. These people aren't even all connected at all. There's several attorneys up there, probably a lot of attorneys who think the judge overstepped here and willing to help with this. So my guess on that is, while I appreciate what you're saying, is I feel like they're advocating, and this is their way to advocate. This is their way to humanize Alan. Okay. That's where their sympathy is in this situation, not just with the lawyers, but it appears with Alan himself. So they're trying to humanize him to the Supreme Court. Will it work? I don't know. And maybe that's how they do it all the time. All I was saying earlier was that I think it's a stylistic situation. And if I were briefing this to the Supreme Court, I would just call him Mr. Allen. I don't think people at the level of sitting on the Supreme Court really going to be moved by whether you use somebody's nickname or not, whether they like it or not, or whatever. Yeah, I would use the people's proper names, like, Attorney Rozzi, right? They call him Brad or something like that. And he's the one kicked off. He's the one you want to get back on there. So, yeah. But it's just not how I would do it. But I think the arguments are good. I've noted already my disagreement, at least with how some of them are portrayed there in terms of the limits of what a trial court can do in terms of disqualifying counsel. I think they have that too narrow. I think the Attorney General is right. That's too narrow. That's not the same thing as saying that the limit is as broad as what happened in this case. That's what we're reading about. So Baldwin, of course, filed a motion to reconsider his removal as counsel, arguing that the judge lacked jurisdiction to disqualify and that there was a motion for her recusal pending. But she didn't take any action on that. That's when she said, hey, clerk, take these out of the record. We're striking all this. I don't even want to see it. These people are gone. And that's when she had said in court, you're out of here. Or actually, I guess right after that. The day before the next scheduled hearing on Allen's case, Baldwin and Rozzi entered their appearance on Allen's behalf as private counsel. And that, I think, was definitely a great move by them because, first of all, it's their re-entrance into the case. So if you're disqualified as appointed counsel, re-enter as private counsel, and you're putting the judge on the spot there because a privately retained counsel has the higher level of rights in terms of your choice of counsel. So if you're the judge saying, I'm not going to let you choose these lawyers because they're disqualified from appearing in this case, I think it's more important than ever to show the basis for that on the record, and the basis be something that survives a balance between Allen's rights and what the judge is trying to achieve by disqualifying them. And they argued there that the judge didn't have authority to remove them as counsel. So they're saying that, look, 6 times we told the court, you can't disqualify us. And therefore the issue is presented to the trial court. And that's true because one of the arguments, obviously, that the AG and the judge were making is you haven't met predicate conditions to filing this. And one of those is adequately presenting these things to the trial court for decision first. But I think Allen has the better side of that here. The judge made a ruling. These guys are disqualified, right? She did do that. So And part of that, what she did in that was, I'm not going to look at your motion for me to recuse myself either. So, what does Richard Allen think? Well, so far as we know, what he thinks, based on the document we've seen, and maybe even some comments or whatever, is he wants Baldwin and Rozzi to represent him in the case. That's I think, the stated position, and even the position that the judge accepted, that Allen wanted those two attorneys, and that they entered an appearance as privately retained attorneys. So, you know, there are a lot of things out of order in this case. It's all whack, that's for sure. So it's good they have a Supreme Court to sort it out. Here's a good point. The judge delayed the efficient administration of justice, they say, that this was particularly harmful, severing the attorney-client relationship because it delayed the efficient administration of justice. And the AG argues the need for efficient administration of justice should be balanced against the defendant's Sixth Amendment rights. Yeah, exactly. Exactly. And they talk about all the cases here where the Sixth Amendment rights, especially choice of counsel and things like that, normally you see that if it's going to be denied by the judge because the defendant is playing games at the last second to get a trial thrown off and screw over the witnesses and the whole system and stuff. And if that happens and it's apparent enough, the judge may deny it. Here it was Allen's side that was attempting to move the case along more rapidly. So this is the opposite of a normal case like this. They talk about last second gamesmanship by the defendant and stuff. And of course, that's the reverse here, which they say the opposite situation occurred here. Respondent delayed proceedings to insert counsel of her choice. When the judge severed the attorney-client relationship in October, a trial was scheduled to begin in January. We know that Baldwin and Rozzi spent a long time preparing for that. And they said, we're ready to try this case in January, and nothing in the record suggesting otherwise. But they're pointing out that, look, the judge hadn't even ruled on some of the substantive motions, including the Franks memo. She hadn't read it all. Of course, apparently she did have a lot attached to that. The motion to produce 404 and 405 evidence, and that would decide whether they would put Allen on the stand or not. That had been pending for nearly a year. I can't say I'm familiar with what they had in that motion, but pending for a year on anything that's really important to decisions at trial, if it really is, that's bad. And motion in limine on ballistics evidence, I know that one's been pending because I read that a long time ago. And request for a transcript. So they're saying that a lot of this stuff has just been hanging out there for a long time. And if anybody was keeping the case from moving forward, they're saying it was her because she could have issued orders on some of these things. So I don't know that that's exactly on point for what they're trying to achieve here, but I understand what they're saying. Don't think the judge will recuse herself, do you? Well, she could have done that. I mean, she did issue an order putting things on the public record, a lot of the things trying to moot out the first action that was filed at the Supreme Court, the first original action. And then we know the news came out that she was sick and she's working from home. If she were going to recuse herself at this point, it would have solved a large part of this. It might have solved all of it. Okay, so let's say hypothetically she recused herself at the moment she got sick. New judge comes in, then potentially Rozzi and Baldwin can say, hey, new judge, revisit this motion. And that judge keeps it or doesn't keep it or whatever. And maybe we're not all... So a motion in limine is when you ask the court ahead of time before the trial starts typically to, hey, I want this evidence excluded. That there's maybe there's a Miranda problem or something like that, a suppression or some issue with a piece of evidence, and you want to go ahead and get a ruling on it before the trial starts. And they like that. The judge likes that if it's important things, because then you don't have to stop the trial to deal with it. So let's take, for example, what this one's really about, the ballistic evidence, the unfired cartridge. So they made, which they rightly should, even if it's strong on the law or not, a motion in limine to exclude that for the various reasons that they stated. So let's say the judge rules pretty promptly and says, no, I'm not going to exclude it. I'm going to let it in. Well, then the state knows, and Allen's counsel knows, okay, we're going to have to be dealing with this ballistic evidence, or tool mark, I guess I should call it tool mark evidence, because nothing was fired here. And the defense knows it too, and so they can go get their own expert. They can prepare their cross-examination. If the judge, to the contrary, said, I looked at this new case, or I found this fatal defect in something that the state presented for this type of evidence, I'm going to go ahead and rule that this can't come in, then you don't have to go get your own expert, and you don't have to prepare cross-examination, and the state knows they're not going to have this evidence. So that's why a motion in limine can be important before a trial starts. Otherwise, let's say you get 3 days into the trial and the judge hasn't ruled on it. Now what do? You're going to sit there and argue with the judge for a little while and the jury's out of the room. You see that in cases sometimes too. If the creative attorneys do not remain, with the succeeding attorneys be obligated to carry on with the fantastical theory of the crime? And no, they wouldn't. And that's one of the things Judge Gold said is you can read the Frank's motion to the new attorneys and decide if you want to adopt it as your own or not adopt it, abandon it, or maybe do something else. And again, the Frank's memo really, that's supposed to suppress the results of the search from his house, which so far as we know, didn't result in much really of any distinguishing nature, except potentially for the handgun that supposedly matches this round found at the scene, which is potentially material. So that's another angle for them to attack that. But it is my opinion that the Frank's motion was much broader than what was appropriate for the types of things you consider under Frank's, and instead was an entire different theory of the case. And it is not up to the state to disclose to a judge in a search warrant every potential theory of the case, because if you go with this Odin thing, then why don't you also have to discuss the clients, because you have researched them a lot and one of them was in contact and all that. Why don't you have to discuss Ron Logan and the things that made him suspicious and the other dirtbag that lived down the road that they thought might have done it? Plus, as far as the internet is concerned, everybody did it. You know, each member of the family had something to do with it. Anybody who came on the trail later had something to do with it. Does the state have to do a 500-page catalog of every single theory of the case before you get a search warrant on somebody? No. That's not really what Frank said. So I get what the defense was doing there, which is being as broad as possible, and plus getting out there their theory of the case. But if these guys don't come back, then we'll see what the new defense attorneys want to do. What does that bullet mean? I won't derail this to go to that. I'm just going to leave it like it is, which is there was a round found. It was unfired, a .40 caliber round found at the scene. Everybody can dispute how it was cataloged and stuff like that. I'm just telling you what the situation is. There was a round found between the girls, and it's a .40 caliber round. And what the state is saying is that when they seized a .40 caliber SIG 226 and put it through tool mark analysis, that the extraction marks on the round found at the scene, because they found extraction marks, which means the round was chambered into the barrel of the gun and then it was removed again, that when they chambered rounds into his gun and took them out under microscope, the examiner says that they match. That might be right. It might not be right. That's not really the point of this stream, but that's what it's about. And the defense says the science behind that is bad, and you shouldn't let this in. The state says you should let it in, and that motion is still pending in front of the court is really what it comes down to. So, all right, let's see. I think that, the question is, didn't the theory come from the state's discovery? Well, elements of it did. But again, they looked into Ron Logan. They looked heavily into the clients, right? I mean, they investigated the heck out of those people. Also other people. So that's my thing is to get a search warrant on somebody, you don't have to discuss every single possible theory of the case. You really need to hone it in on what they talked about were the misrepresentations involving the search for Allen, okay, of his home, and I think it was his home, maybe in his vehicle, where the search warrants they were attacking. So the theory that there was probable cause for Allen is what you've got to attack, and an alternate theory of the case is not the best way to do it, because there's not really an obligation to discuss all other theories of the case. So whether those theories might later be correct or not, okay, because we're talking about a search warrant. Anyway, the remedy on appeal is non-existent. Only an original action can achieve a speedy trial with Rozzi and Baldwin at the helm. This guy's a pretrial detainee. He's over 50 years old, deteriorating health, housed in prison among individuals who've been convicted of crimes. He filed the writ for Rozzi and Baldwin to be reinstated and to remove the trial judge and to get a trial within speedy trial time frame. Only this court can deliver that relief. Well, that's correct, I think. The part about only this court can do it. And I'm sure he's over 50 years old, so some of that stuff is true. I mean, generally, this is true. So I don't quibble really with that. The interwoven connection between the speedy trial request and the Sixth Amendment violation. Yeah, let's see what they say about that. The murder charges filed in October 2022. The trial was set for January of this coming year. And he had a right to assume the trial will be held on that date. Okay. His past attorneys, Rozzi and Baldwin, spent a year reviewing everything, and it certainly looks like they did, right? I mean, they certainly have worked the case. They've done a lot of depositions, a lot of thinking about what they were going to say, and developing at least one alternate theory. Doesn't mean it's the only one that they might have. So, you know, if you're the defense attorney, you want to show the flaws in the state's case. It's not your burden to do anything. It's on the state to prove beyond a reasonable doubt every single element of the crime. But you don't want to just sit there and look at the wall, right? So one of the things you're going to do if you're the defense counsel is try and poke holes in the state's case and show where they do not do that for the various elements. So you attack their case directly. Another way to attack it is to show some other theory of the case that's supported by some type of evidence that has some reasonable plausibility to it, because if this thing could be true, it reduces the chances that that thing could be true, right? This can't be, if this is a 30% likelihood this happened, then this over here can't be 100%, right? So that's what they were doing, and it seemed like they were energetic about it. Removing the judge without good cause would set a precedent for defendants being able to can judges they don't like. Agree with that too. And this is the whole problem with all these cases, is there often are fair points on both sides. That just, there are. And of course, we haven't gotten to the part about the judge being gone. Right now, we're still in the part of the brief about saying they want Rozzi and Baldwin back. And I think that matters a lot. I think if you find, let's say that the judge was within her authority to get these guys off the case and appoint who she appointed, then you can't also say that she's unfairly biased. So why would she need to leave the case? Right? But on the other hand, if she was so outside the bounds of the law here on what she did, and for the reasons she said, it might be hard to believe that she could be unbiased towards these attorneys going forward, because she's basically said that they have lied and that they're incompetent. So the situation is complex, that's for sure. So they say that the judge thrust new attorneys on Allen, who was unprepared. They are unprepared for a 3-week trial. Well, yeah, they just got it. I mean, in theory, they have other cases. They weren't just sitting there with no cases waiting for this one. No attorney coming in this case can be ready for a trial this complexity within that time frame. And I think that's probably true even if you didn't have any other cases. In short, only attorneys Baldwin and Rozzi can be ready for trial within the limits of Criminal Rule 4. Okay, so then finally I get to understanding exactly what they're saying with their logic, which is he has a right to demand a trial within a certain time frame, apparently under their rules. And the judge's decision to remove these attorneys have destroyed that right, because no attorney can be ready within that time frame now. Now, again, it doesn't mean a judge can't do it, but you put that on Allen's side of the scale. Allen is saying you're delaying my trial by taking these lawyers away. And that's certainly a fair point to Allen, because he should have a prompt trial and everyone else should too. Then you weigh up these things for Allen, and then you look at what the judge is saying. Yeah, but, and then you put the things on the other side, and then you don't just have an even scale. You have some kind of legal parameters defined by the Constitution, case law and stuff that will tell you how to measure this, how to weigh this. This one must outweigh that by this much, or just a little, 51%, or a lot, so that kind of thing. A direct appeal after a jury trial is wholly inadequate. I agree with that. Let's say the judge is just totally wrong here. Making Allen go to trial a year from now without having an appeal at this point, or a way to address this at this point, is a disaster for everybody, okay? Let's say he's totally innocent and he gets acquitted, but he had to wait a whole extra year in prison. Well, that's terrible. That goes onto his scale there. Also, if he did it and he's convicted, that's a terrible thing, because now he's got an appeal issue. And if the judge's error is outside the bounds of the law, isn't that better to figure that out now rather than wait until he's convicted and have to try the case again? In fact, while I'm reading this, while I'm talking about it, I see the final line here is trial will be for practice only, because there'd be an unresolved Sixth Amendment issue and everybody be dragged through a constitutionally infirm trial. I think that does matter. Now, that's not to say they should win this, but I think it does support their idea that this should be decided now for everybody's sake, which is what they are saying here. Somebody says that she appointed really bad attorneys for this case. I know she did appoint one that is an alleged Facebook friend of hers. And I will say again that depending on the jurisdiction you're in, that is not necessarily anything bad. It all depends on where you are, the limits of social media presence and use by judges and stuff. And, they can be friends with people, but they can't endorse this thing, or, it's pretty wild how the law is struggling to deal with social media. Now, the guy I haven't been on TV talking about the case, and that's less than optimal, right? Yeah. And Okay. I don't know that they've been raised at this point, but you can bet it would be raised on an appeal later if he were convicted. Another reason to decide this now. Yeah. The guy publicly, yeah, exactly. He commented on that. I saw those interviews. So yeah, I kind of agree with that. All right. Sixth Amendment will permeate, issue will permeate every aspect of this case. The remedy on appeal will be retrial, not retrial with attorneys Baldwin and Rossi. He wants a trial with them. Only this court can grant that relief. And it's not so much that it's with them, although that is an element of his argument. Their other argument is anybody else but them takes a year to get ready. But you can see now we got a big problem because the January date is, I think, blown, I think. And especially if you throw off this judge, because you got a new judge coming in who's going to have to read the 8 gillion pages for the Franks memorandum, all this motion in limine, the state's motions, whatever other defense motions. When can that judge be ready to try the case? And the judge probably has a schedule as well. So this is currently a big mess. Even if Allen is acquitted in October 2024 or whenever after that, justice delayed is justice denied. And it's a fair point, right? We don't want people languishing in jail unless they need to. It doesn't say automatically, oh my God, he gets whatever attorneys he wants and they can do whatever they want. It's not that. It's all kind of a balance within the concept of what his rights are and how much those can be curtailed in the interest of what the court can do to control its authority over, what she says are the bad things that these guys did. It's a little... this is the end of the responses. This will be the last one. And then the Supreme Court will respond to that. And I don't know when they'll do it, but they'll probably do it pretty quickly. This is no appeal. This is an original action. They understand what is going on, I think, right here. And they've been on it, right? This attorney asked for, I think, permission to file this today and got the order today. So I don't think they're going to set on this. I just don't. If they wanted to throw it out, by the way, they could have done that already. They could have said, well, you didn't meet this requirement. We don't have to hear anything else. So I think this one will get a decision in writing that may illuminate the law for the state. Interlocutory appeal would only exacerbate the harm Allen has already suffered, even under the best of circumstances. That appeal takes months, right, before a decision is reached, assuming one can receive permission from both the trial court and the Court of Appeals. Yeah, so some of these things kind of are appeals of right, interlocutory appeals of right, but some of them are discretionary and you have to have certification before you can even pursue them before the end of the trial. And that, I think, is an important point here to decide this at this phase. And since the court has decided these sorts of things before at this phase, I don't see a dodge coming. I just don't. They're letting them file all this stuff, and if they weren't even going to listen to it, why not stop that earlier? Although procedural, you never know. They could just let it stack up, and then they all get their files, look at it whenever they have a time scheduled together, talk about it, and somebody writes a decision, and boom, there it is. Given the judges, okay, so here we're getting to the part about they want the judge gone. So we've heard what they've said about why we want Rossi and Baldwin back, which is largely due to Allen's preference for these attorneys, their private retention notice that they put in, and the fact that they can go ahead and try the case, okay? Weighed against what they say is the judge's alleged basis for her decision to throw them out, they say, is not sustained by what they actually did or the magnitude of what they did. So that's their idea there. A judge shall be disqualified in any proceeding in which her impartiality might reasonably be questioned. Oh boy, we got that word reasonably, don't we? Reasonably. Yeah. The judge argues that neither Allen nor his attorneys demonstrated that the judge has any bias or prejudice toward them. But they note that before the circumstances surrounding the discovery leak had been fully investigated, the judge indicated she was leaning towards disqualifying counsel. That's not necessarily going to do it, but that's not bad to open with. Let's see what else they got. The judge also claimed counsel's motion for an immediate transfer of custody for Allen had a lot of inaccuracies when compared to the state's affidavits. And that the judge indicated she was denying the motion, even though hearing on the motion had taken place, and he was given no opportunity to present evidence. Well, if he had affidavits, I mean, you don't have to have a whole trial over that. Again, in my opinion, I would have tried to get him into jail instead of prison, but I don't know how far you're going to get with the judge on that, except as you relate it back to the judge accusing you of being a liar about it. because that's different than disagreeing with it or saying your motion was weak or your motion was terrible. To actually actively say that you falsified things or filed false things is pretty strong. Respondent said the same thing about Allen's motion requesting a modification of the safekeeping order filed back in April 2023 containing inaccuracies and falsehoods. Yeah. So the judge based that on the state's evidence presented at a hearing, but failed to acknowledge that the judge relieved the sheriff of his burden to transport Allen's primary witness to the hearing so he could testify in support of Allen's motion. I guess that was that. Maybe that was that prisoner who said he saw these things going on with Allen and wasn't allowed to come testify, I think is what they're suggesting here. And it kind of cuts off there. I don't know. Maybe there's a word limit or something like that. I don't think those things do it. If that's the end of this, I think I probably, again, it's all choices and probably limits on how much you can write is probably a big thing. And they know, as long as you get it into the facts and stuff, the Supreme Court doesn't need you to spoon feed them what the consequences are to the facts as they're set up like that and the application of the law. So the idea here, I think, if you want to read between the lines, like they say that lawyers are supposed to be able to do, is the idea is if the judge said, I think that you filed falsehoods, okay, you basically lied to the court there and you've broken professional rules of responsibility multiple times. Now, let's say the Supreme Court is aware of what happened here and disagrees with the judge's assessment on that. Let's just make that a hypothetical for a moment. And also the magnitude of responsibility that Baldwin have for what happened, say, with the discovery. Then could you reasonably say that this judge just can't see these guys in a neutral light anymore? If you think the judge was wrong on these things, that she sees what they do, but then she puts something on it and then calls it a violation of the rules and falsehoods rather than just being wrong. Now, obviously she's right, then they're going to lose all of this. But if they were correct to the magnitude that the Supreme Court would reverse this judge and say, no, we think Rozzi and Baldwin should be back in the case, then I think it makes Allen's case stronger to say that the judge is biased against these attorneys because this judge didn't have the facts to support her decision. What supported her decision really was her perception of these attorneys. And how can it be said going forward that her perception would be neutral to these attorneys if it wasn't based in an adequate amount of facts and law to begin with? I think that's the nature of the argument. So I think if they lose on the first part, getting Rozzi and Baldwin back, they don't get a new judge. But if they win that, they at least have some case here for the removal of the judge. It's also possible that they say Rozzi and Baldwin are back and we order the judge to consider the recusal motion and then we'll look at this. But I don't think they'll do that because I think they have an exception for original action. They can go ahead and hear this change of venue, they call it, when you want to switch out from the judge, a recusal situation. So I think they'll issue the order on both of it, and we'll see if they divine through the logic of this that the judge could, not that the judge would be biased. That's not what the law is. The law doesn't say we have to read her mind and know in the future that she absolutely will try and screw these guys over. It said, what was the standard that they quoted? In which impartiality might reasonably be questioned. Now that's a broader field there. It doesn't require as much mind reading. That says a reasonable observer watching these proceedings would say, I don't think you're gonna be able to be fair to these guys because of how you ended up perceiving them through this, and you're not gonna like them anymore for taking you to the Supreme Court twice and getting themselves put back on the case. We'll see if they're persuaded by that. I think that is. So the question here is there de novo reasoning of review her reasoning behind her rulings. It's a good question in terms of what the standard is there. She has like an element of discretion. So in that regard, there's only so much you can do. But I think what they probably won't do really is quibble with the facts. But I think what they probably will do is articulate some limits to what. See, here's the thing. I think you can say the judge didn't apply the law here correctly. Okay, I think you can say that. Because of the way that these orders came down, and reverse it for that reason. I think you can do that without questioning how she found even the underlying facts of it. Although they might go further than that and say, well, even if these facts are true, if they were to say, if these facts are true, that does not support a legal way to throw these guys off the case. Even if these 5 things happened or whatever the number was, that's not enough under the law to throw somebody off the case. Then you wouldn't really be questioning her reasoning. You'd just be saying, hey, this is just what the law is, and you've just stepped outside of the law. So if you have a legal error, that's different than, you know, an area of discretion of applying the correct law. And because this was handled in such a vague way, I think the Supreme Court could come at this from a number of different angles. And it's certainly possible that they could say the judge was within the bounds of what she could do. And if they say that, they're not going to remove her off the case, because why would they? But I think there's also a basis that they could put these guys back on. That's my opinion. And my opinion is that it should have been handled with some lesser sanction. But you know, that's different than saying that it's completely for certain reversible here. If she wanted to protect him, she could have had a hearing and not dragged cameras in just to tar in front of the attorneys he liked. She didn't want to do any of that. She just wanted them gone. She certainly did want them gone. Now, I will say about the cameras, his attorneys made a big deal out of it. Let's start getting these cameras in his courtroom. Of course, I don't think they imagined the first time they were going to do that would be when the judge wanted to come in and disqualify them by telling everybody on TV that they're incompetent and grossly negligent. So I get what you're saying there. The judge could have, given the sensitivity of what she was deciding, not chosen that time to grant the defense's desire to have anything televised, and said, well, you know what? We'll look at the TV camera next time, but this next one, we're doing this the old school way, because I'm going to need Alan in here. It's going to need to hear some things I might need to hear from him. I thought this is not the time to put this thing on TV, and given some different notice. So does all that amount to, you know, that she was outside the bounds of the law, and also whether therefore she's biased against these guys? That's what this is all about, right? The first time the cameras were brought out was a pre-written decision to remove them. Shouldn't cameras be allowed in audio anyway? Well, that's always up to the judge, right? And they weren't doing it before. Okay, they weren't doing it before. They were doing it this time. And, you know, whether there's cameras, that's just going to always be up to the judge in any individual circumstance. And even if you generally were having cameras and you were going to have something particularly sensitive going on, there's no reason why you can't stop the cameras. But there weren't cameras going on before this. So, yeah, that's the thing about that. Yeah, so you might, you know, I'd have to see the timing of when the judge said, yeah, we'll do cameras. Was that before she knew that this leak had occurred, or after? And if it's after she knew it and after she was already mad about it, then I could understand why you certainly would think that she decided she was going to load this up like the OK Corral. If she said cameras before that, it's possible that they just hadn't gotten around to canceling that, or anybody even asked for it. It's just not a good situation all the way around. So that is, I think, the end of the thing, because that's the conclusion right there. This court is the only court now that can ensure that Alan receives his fundamental right to counsel. I do think it is in the right place. Whatever the decision may be, a writ of mandamus is appropriate to reinstate these guys. Okay, that's an active consideration. That's issue A. Set a trial date within 70 days from the issuance of the writ. I don't think that's going to happen, because if you get a new judge, you're not going to dictate the judge's schedule just as the day the order comes down. But I understand why they're asking for it, and to remove the special judge and appoint a new one. To get that, I think you have to get the first one. And if you get the first one, then you still got a little bit of lifting to do to get the second one. So are we talking about cameras in terms of all other states? All other states do not have cameras. And the vast majority of cases are not televised. There are a lot of cases out there, and it's up to the judge all the time. Look at the Daybell case where they didn't televise Vallow, but I think now they say they are going to put some cameras in on Daybell, but maybe it'd be court cameras. And with the Koberger case where the judge was allowing some cameras in there, but then found that was not operating the way that the court needed it to, and said, well, we'll do it in the future, but the court will handle the cameras. Sometimes they have cameras, sometimes they don't. I think I'm not sure if your question was making a point that they don't have them or not, but either way, that was the answer to that. She only allowed the cameras that one day, and that's it. She was going to humiliate him. I hear what you're saying. I hear what you're saying. And if a reasonable person thinks that in the Supreme Court's eyes, then that's material to obviously what they're asking for here. So, All right. And so that's this. That's it. That's all that should be said in this before the Supreme Court issues its decision. And then this case can potentially get back on track. I think, if the Supreme Court doesn't grant what Allen's attorneys want here, then no one's on his side is going to be happy about that, because the case is delayed and he's going to have new attorneys and stuff like that. So I wouldn't expect anybody to be happy about that. And if the court does grant it, we'll have to see how that shakes out, because we don't know who this new judge would be, right? And how they're going to handle this case and all of that, or even when they'll handle it. So, and it is unfortunate how it has flown out. Yeah, why didn't she do it the normal way with a written motion? Now, she can sua sponte, knock it on out of the park, and she did, but that doesn't mean that you don't justify it the right way. And remember, of course, I think the idea here was that these guys were going to withdraw, and then she could stand on their withdrawal, and then there wouldn't be any order about disqualifying, right? That's how this was going to go. They were going to withdraw the case, stay that way, and then it would be the new lawyers. That's how it was going to come up. So I understand why people could have a criticism of the judge in this case. I get that from the circumstances. So I respect that. I don't know the full answers myself, but I like to have a process that looks clean in its execution. And ultimately, even if you don't like, say, Baldwin and Rozzi, the judge runs the courtroom. And if she's wrong here, she's wrong here. This wouldn't be the end of the world. Get it fixed and get on with life. I mean, it's terrible, but bad things happen, and the best you can do is fix it and move on. I just would have handled it differently myself. So she bluffed him into withdrawing. Well, maybe, but I think she was also prepared to get on out there, and allegedly the state had people ready to call. I think it was reasonable for Rozzi and Baldwin to think that she's holding the cards, man. She's the house. She's the judge. She gets to decide what she's going to do. And I think she would have gone out there and said, I'm disqualifying you for these reasons. But I think she should have done that anyway. Then we would all know where this thing stands, because she ended up having to kind of do it at the end of it anyway and say, look, what happened in the last 12 days? You guys I'm not letting you in this case. You're disqualified. You're incompetent. So it ended up all being said anyway. And now we're in more of a procedural thing there. So yeah, Kevin said she was not bluffing, and I agree with that. I definitely agree with that. But if they had stayed and just said, look, we're withdrawing out of case, and hadn't said anything, then we wouldn't be hearing all of this, right? Yeah. So I hear what you're saying there. But we ended up getting the transcript, and interestingly, I think it's basically supported Rozzi's version of what happened in there. So she used the cameras to leverage it, but I agree with Kevin. I don't think it was a bluff. I think because in a bluff sense, if they had said, well, we're not withdrawing, what would have happened then? I think she would have marched it right on out there and let the state do whatever they were going to do. Let the defense say anything they could think of in response, and then go, you're negligent, you're incompetent, and therefore I'm able to knock this out. Yeah, she should have had a hearing. Well, I have done this without killing this tree, which is good because I'm left-handed, so I'm having to dodge this to the maximum degree that I could possibly do. But thanks everybody for coming by on your early weekend evening. And now, so I won't have to touch this case as much tomorrow, but we've got some entertaining but not as deep topics for the weekly docket tomorrow as we scan through cases across the country and take a look at those. They won't be reading through an entire brief. There'll just be some the crazy antics of what people do. So anyway, that's it. If you don't come back tomorrow, then I hope you have a good weekend, but hopefully I'll see you tomorrow evening when the weekend is well underway. Well, that's it. Thanks. Bye.